Hi, welcome everyone to the fifth briefing hosted by the Act for Public Health. My name is Tom Pryor. I'm a lead senior staff attorney at the Public Health Law Center in Minneapolis, Minnesota. I'm excited to be joined by my colleague today, Wendy. And Wendy, do you want to introduce yourself? Oh, I think you're on mute.
Thanks, Tom. Welcome, everyone. Wendy Parmet. I am the faculty director for the Center for Health Policy and Law at Northeastern University, and we are a member of the Act for Public Health Coalition.
Thank you. So again, thank you all for joining us for this twice-a-month briefing series that the Act for Public Health has been hosting to help explain and interpret the impact of recent federal actions on state and local public health practice. The Act for Public Health is a partnership which includes organizations like Wendy and my organization, as well as our host today, Change Lab Solutions, the Network for Public Health Law, and the Center for Public Health Law Research. Now, for today's discussion, we're going to be focusing on litigation. We're going to give a brief overview of some landmark cases from the Supreme Court from this past term. We're also going to focus on a lot of lawsuits that have been percolating through the judicial system that are relevant to public health. And that's why I am particularly excited to be joined by Wendy today, because she's really at the forefront of this field in tracking and analyzing litigation and its impacts on public health. As a quick note before we begin, the Act for Public Health has created some really great resources on other actions from this administration, as well as executive orders. I think Leslie's going to be posting some of those links in the chat right now. I also know that all of the law centers that make up for the Act for Public Health publish frequently on executive actions, orders from the government, and ongoing litigation. So please do check out those individual websites, which you can access through the Act for Public Health website as well. Just a kind of housekeeping point, we're going to be posting links in the chat, but all of the links and resources that we post during today's discussion are going to be available to you afterwards as well. So don't worry if you miss something. I'm also going to note that the chat is open, so you can kind of talk amongst each other, share resources, commiserate, engage in some camaraderie there. But Wendy and I are not going to be actively monitoring it. So if you do have questions for us, we will try to get to them, but we'll probably be after the fact since this is a short webinar. And because it is short, I'm just going to jump right in. So Wendy, there were a lot of really important cases decided at the Supreme Court this term, many of which impact public health. I'm hoping you can maybe talk to us about a handful of them that were released towards the end of the term, in particular U.S. v. Scrimeti, Medina versus Planned Parenthood, and Kennedy versus Braidwood Management. So all three of those really directly impact public health. I'm going to throw another one on the pile, though, which is the Trump v. Casa case, the birthright citizenship case that's also about universal injunctions. Because even though that's not directly about public health, it really impacts litigation over public health and really everything else. So it's a tall order. I'm wondering if you can give us a kind of mile-high view of those cases so we kind of understand what's going on.
Sure. Thanks, Tom. Yeah, a lot of cases to talk about where you pick the big four for the moment. And I'm going to have to go really fast because time is limited. But let's start with Scrimeti. The plaintiffs in that case argued that a Tennessee law barring gender-affirming care for minors discriminated on the basis of sex in violation of the Equal Protection Clause. Briefly, they claimed that because the Tennessee law would allow the same treatment to be offered, let's say, to a person born male, assigned being male at birth, to support their being male, but couldn't be assigned, prescribed to somebody who was born and assigned to be born at female at birth, it was sex-based discrimination. The Supreme Court, by a 6-3 vote, disagreed with the plaintiff's arguments, ruling that the law did not discriminate on the basis of sex, and that the statute merely prohibited a type of medical treatment for a type of medical condition. This was a medical classification, the court ruled, and should be reviewed, therefore, only under the highly deferential rational basis test, which, of course, the court found the ruling satisfied. Beyond slamming the door to challenges against state bans on gender-affirming care, it's important to note that the court's reasoning suggests that it would rule similarly for gender-affirming care for adults. And by the way, in another case I'm going to talk about a little later, lower court just this week said, discrimination on the basis against groups on the basis of LGBTQ no longer gets strict scrutiny, because the reasoning of the court really goes to the heart of the idea that discriminating against people because of their gender identity is discrimination on the basis of sex. The other thing I will note, something we've talked about a lot in Act for Public Health and our other publications for a long time, is the attack on expertise. Justice Thomas, in a concurring opinion, really went after the so-called experts. His disdain for scientific evidence is not surprising, but it should be alarming. Look, going quickly to the next case, Medina versus Planned Parenthood, was a challenge to a South Carolina law that barred Planned Parenthood from participating in the state's Medicaid program because Planned Parenthood also performed abortions which were not covered or paid for by Medicaid. Now, many of the people listening to this might say, well, the case is sort of no longer important since the one great big beautiful bill sort of created a national law that's similar to South Carolina's and is forcing Planned Parenthood to either get out of the Medicaid business or get out of the abortion business. But what's important to note, besides the impact on Planned Parenthood and abortion services, is that the court issued its decision not based on abortion, but based on the idea that individuals or providers really have no right to sue under the Medicaid Act, except in extraordinary circumstances. This case really seems to slam the door on so-called private rights of actions for violations of the Medicaid Act. And that's going to very likely have a green light effect on states can ignore parts of the Medicaid Act that they don't like. And the only remedy would be get the Trump administration to go after enforcement. And in certain cases, I think that we might say that might be unlikely. So the private right of action, being able to go to court to get redress for Medicaid, has really been stopped. The third case, Kennedy versus Braidwood Management, on its face, this looks like a win for public health. And I don't want to diminish that because the court upheld the preventive care provisions of the Affordable Care Act. Yay. That's important. But the court's decision only did so on the theory that the Secretary of Health and Human Services, Robert Kennedy, really has authority over members of the U.S. Prevention Services Task Force. And not to get too technical, but the legal challenge was based on the Appointments Clause and the authority and way that the task force was appointed. As a result, the preventive services provision is alive for another day. But it really also means that Robert Kennedy Jr. is pretty much free to fire and replace the task force members, as he did for the members of the Advisory Committee on Immunization Practices, and override their decisions willy-nilly. And so, it's a victory, but there's a poison pill in this victory. And finally, I want to talk about Trump versus CASA, the birthright citizenship case. As many listening probably know, this was not a case on the merits. It was a case based on the idea of the question of whether lower courts can issue what are commonly known as nationwide or universal injunctions. So whether the plaintiff states that argued that President Trump's executive order on birthright citizenship was unconstitutional could get an injunction, as they got, stop blocking the executive order from taking effect nationwide. Now, on the one hand, this is going to affect health because we anticipate there's a strong likelihood that in many states, the birthright citizenship executive order will go into effect. The court stayed its own decision for 30 days, but it's likely to go into effect in the states that did not sue, i.e. the red states. That means a lot of folks a lot of babies who would have been eligible for Medicaid and other federal benefits will not be. That has very harmful effects to health. But the injunction, the ruling about the injunctions also has implications for many of the other cases we've been talking about and we've been watching. And so it will mean it's much harder for the lower courts to give relief when a federal executive branch acts unlawfully. And so there are still some potential pathways that some of the justices talked about. I don't want to go into the legal weeds, but it's going to be much harder to get nationwide relief. And we are probably going to see more and more of a patchwork of different outcomes in different orders, different effects in different states. So just in case everybody hasn't had enough chaos in the last couple of months, more chaos is coming our way.
Yeah, I appreciate that. Thank you. So much to talk about on those. We could spend probably a whole day on any one of those cases. The Casa case in particular really struck me as a sea change in constitutional jurisprudence and the power of the courts, because, intuitively, I think if something's unconstitutional in one place, it's unconstitutional every place. And so when you go to a district court judge and they say that this action is unconstitutional, then the government should stop enforcing it anywhere and everywhere. And now that's no longer the case necessarily. There's other, as you say, there's other vehicles, other ways to get there, but the fallout from this is really going to be something to watch.
Yeah, I'll just add, I mean, I've been a critic of nationwide injunctions. I think they have been abused. I will note that this current Supreme Court never saw a problem with them in the Biden administration, and lots of his initiatives were blocked by nationwide injunctions. I think a lot of people were hoping that the court would use this as a vehicle for really examining carefully when they were appropriate and setting some criteria so that they could not be imposed willy-nilly. But if any case deserved a nationwide injunction, it was this case, right? I mean, it was this case. I'm in Massachusetts. Our border is New Hampshire. Whether the baby is born on one side in Nashua or Lowell should not make a difference. And people travel around. If any case was an appropriate case for a nationwide injunction, it was this case. So in a decision saying, well, district courts, be careful, you need a compelling reason. I mean, we could imagine what that would not have been surprising and might have been welcome. But this case, I mean, they're really slamming the door and saying, no matter how compelling, no matter how strong, never can do it. And that's really deeply troubling, troubling.
Well, of course, as the court notes, too, in the opinion, that you can still get something that is like a de facto nationwide injunction if and when the case comes up to the Supreme Court and they rule upon it, thus setting precedents for the entire nation. But as we've seen from the handful of cases you just told us about, there's a trend in those Supreme Court opinions. And so I think we know what that means. So it's kind of those two trends. One is the court kind of condensing power for itself at that Supreme Court level, and the other trend of having really administration-friendly rulings.
Absolutely. Yeah. Absolutely.
Well, so I want to move on because the Supreme Court's not the only game in town. It's not the only court that's making important decisions that impact public health. And so I want to talk about some of the cases that have been percolating through the lower courts, district courts, appellate courts at the state and federal level. I'm going to note, so I think we're going to put a slide up on the screen that will show some litigation trackers that Wendy and I and others have been using, because there really is just a dizzying array of litigation that's been going on in this country, and it's hard to keep track of it and the updates in all these cases. And so these resources will be available to you after the fact. But Wendy, while folks are kind of digesting this content, I wonder if you could tell us about some of the cases that you've been tracking at the lower court level, and maybe some of the trends that you're seeing there.
Sure, thanks. I mean, the first big trend, to be clear, is that the plaintiffs challenging the various orders and initiatives of the Trump administration are having a very good success rate in the lower courts, even though they're kind of batting zero in the Supreme Court. I mean, the dramatic difference is really stark. I can't in my career think of a time where the differential has been this great. Second of all, there is no doubt that the plaintiffs challenging Trump administration cases are engaging in some forum shopping, as did the folks who were attacking the Biden administration's actions. And so what we're seeing, and what we've seen over the many years, is an increasing polarization of the courts. So people who are attacking Biden were running to Northern District of Texas and Louisiana, and the folks who are attacking Trump are running significantly to the District of Massachusetts, less so Rhode Island, California, and DC. And if we had more time, we could talk about why we see that polarization among districts, but just think about the US senators. And so, where are their blue state senators and where are their red state senators? And I think you got the answer for that. Okay, so there are lots of cases, as you said, dizzying. I love that. I mean, yeah, I'm dizzy thinking about it. I just want to mention a few because, again, time is brief. So just this week, oh my God, just this week, the American Academy of Pediatrics and several other medical and public health organizations, including APHA, sued Robert Kennedy Jr. and others in the administration in federal court in Massachusetts, underline Massachusetts again, for, in their words, and I want to quote this, dismantling the vaccine infrastructure and undermining trust in the availability of vaccines. The complaint recites a long litany of actions and statements that Kennedy and his appointees have engaged in, both before taking office and since, and how they really have undermined faith in vaccines and decisions they have made to reduce the accessibility of vaccines. In particular, of course, the decision, which is in the complaint, the directive not to recommend COVID vaccines for children and pregnant women, and especially important, overriding the expert opinions of their own agencies, and also removing flu vaccines with thimerosal. They also talk about his firing of the ACIP, which I talked about earlier. This is one of the first cases, what I want to note, that focuses not on the structure or financing of public health, but actually a set of substantive actions and rules, right? So this one's going to policy directly, not how much money, how many employees. This one is, bullseye. We're getting straight into public health. This case has actually been, again, is in Massachusetts and has been assigned to a judge who I'll talk about in a second. Okay, Judge Young. So in several cases have also challenged the National Institute of Health's rescission of grants. And you'll all remember that in the winter and early spring, all of these grants were being, shall we say, rescinded, clawed back, terminated. This week, same judge in Massachusetts, Judge Young, in a case called APHA versus National Institutes of Health, issued an opinion memorializing his earlier ruling that found that the termination of NIH grants claimed to be related to DEI were illegal. Among his key findings, and this is just, I think, astounding, right, was that the terminations evidenced a pervasive racial discrimination and sex discrimination. Okay, there was discrimination on the basis of race and sex in terms of grants having to do with health equity and people of color, grants issued to, right? That was not the ultimate finding and basis for his decision. I will say he also mentioned discrimination against the LGBTQ community and their healthcare needs, but said after Scrimetti that was no longer a legally viable claim. That was the point I was making earlier in this briefing. He found that NIH had been weaponizing the health of American people, creating chaos, acting in a manner that has nothing to do with research or science, and violated the Administrative Procedures Act. It's really an astounding opinion by a judge who's, not a radical far left judge. It really is an astounding opinion. I will note that a federal judge in California in a case called Thacker versus Trump similarly found that NIH terminations in that case to the University of California system violated the Administrative Procedure Act. And don't have a lot of time, but I will just mention another case, Doctors for America versus Office of Personnel Management. In that case, the federal district court in DC ruled that the decisions by the Department of Health and Human Services to remove or modify healthcare web pages and data sets in compliance with President Trump's executive order to ensure that materials are consistent with the president's views on biological sex whatever those are, and do not endorse gender ideology, was arbitrary and capricious in violation of the, again, the Administrative Procedures Act. Another similar case is also pending in the district court in Washington. There are also cases going on, other cases about data removals, cases about clawing back public health funds. A district court in Rhode Island issued a preliminary injunction requiring HHS to restore COVID funding. That money is running out or has run out. I guess I can't remember right now whether it's July 31st or July 1st, but still important. And then there are other cases going on. Again, I really urge folks to look at the tracker. I will also say that we send out a newsletter about litigation updates, and I hadn't prepped this, but Leslie, if you can put in the chat how people can subscribe to that. We discuss these key cases on a regular basis in our newsletter.
Yeah, so much to keep track of. Some of which you just want to know about because you care about these things, and other cases because it might directly impact you. So thanks for plugging that newsletter and for going over those. So in the time we have left, I wonder if we can maybe take it up a level and ask the question I know is on a lot of people's minds, which is, with all this turmoil, which everything that's happened in the last 5 months, it's only 5, but can we look to the courts to save us? I mean, what role do the courts play in preserving essential public health programs and public health infrastructure?
Sure, thanks. This is something, I think about a lot, only like 24 hours a day. So litigation is not our savior. The courts are not going to be what saves public health, okay? It matters. And some of these cases I just mentioned, real outcomes can affect real people's grants, real programs that help people. Lives can be saved, but litigation is not the savior. First, as we've discussed, the Supreme Court has taken away the possibility of nationwide injunctions and is hostile to act, and has been, or let me put it a different way, has shown itself to be very deferential to the executive branch under President Trump. So a lot of these orders, the court can't override every case. They're not going to override every case that's done at the lower level. But when cases get to the Supreme Court, and when Trump, he's been petitioning for emergency petitions to override lower court cases without going through the regular review to the appeals court. Supreme Court's been there. It kind of has an open door for the Trump administration. So that's a problem. Also, litigation is where it's been helpful is in cases where the Trump administration has been sloppy, like the grant cases, sending out form letters, no individual decision-making reasoning. The administration can get its act together, possibly, and make it harder to challenge what they do, but also policy changes that are coming through legislation, including those that come through the big, beautiful bill, will be harder to defeat in court, right? Medicaid cuts are Medicaid cuts. And it's one thing to go after the administration for clawing back grants, or it's another thing to challenge congressional decisions. So that's a problem. And of course, even when it can be successful, litigation happens after the fact. It is slow, it is cumbersome, it is expensive. And frankly, we're playing whack-a-mole right now, so there's just so many things coming down so fast and furious. And the organizations that have been bringing these cases are doing their best, but we'd need 500 more of them to bring all these cases. So litigation is important. It matters. It matters for good. It also matters for bad, like we talked about CASA, right? And we talked about scrutiny. I mean, litigation can be harmful to health. So it matters, but it's not the savior for public health.
Yeah, no, I appreciate that thing. And I guess I tend to think litigation as being one tool among many that advocates in this field have to advance public health. So if your rights have been violated, if a law has been violated, but by all means, if you have the resources, litigate and try to preserve those rights. But there's also letters to the editor, there's advocacy, there's protests, there's everything in the democracy toolbox needs to be used to protect these essential public health programs. And we can't just sit back and assume that the courts will swoop in like Superman and save us. So.
Totally. And we have to remember, too, the litigation can hurt us, too, right? I mean, part of the reason why we're in the mess we're in right now, so to speak, is, a bunch of decisions that have been issued over the last many years that have eroded public health powers and have emboldened an executive, long before the second Trump administration. So we need to recognize that it's not just that litigation isn't the only tool. It's a two-faced tool, and it can be helpful, but it also can be harmful.
Yeah, strategic litigation for sure. So obviously, the first step and a frequent step throughout the process is to talk to your lawyer to figure out how best to protect your rights, and what route in litigation, if litigation is the right answer, is the right route for you. Do you have other advice for folks, things that they can think about? Tangible things that maybe they can take away from this conversation?
Well, I think, first, again, what we've been saying, and what you just said, courts matter. So, understand what's going on, keep abreast of what's going on. Know that the composition of the bench matters, right? People often pay no attention to who's going on the courts, except, maybe a Supreme Court nomination or, like the Wisconsin last judicial election that got a lot of attention. Judges, involve yourself as much as you can. To those of you who can, I know, for government workers, there are some prohibitions, but in judicial nominations, it matters who's on the bench. We see this with the Supreme Court. I mean, I talked about forum shopping. It matters whether you're the law matters, but it matters whether you're bringing a case in Texas or Massachusetts. So it matters. Also understand that one of the reasons public health is endangered right now is because it has significantly lost some of the public's trust. It's easier to go after public health when the public is not. So we need to figure out how to be empathetic, persuasive advocates for public health, not only in the courtroom, but outside of the courtroom. Having the public on our side does matter when we go to litigation. And that shouldn't be the case, but it is. And then finally, I just want to repeat what you said, because I believe it so much. We all need to keep doing what we do every day, keep doing the work for public health, keep bringing cases, keep defending cases, keep attuned to the law, write the letters, write the articles, hold the signs, do what we do what we can do to not only be advocates for public health, but citizens of a democracy. As long as we keep acting as if we have a democracy, we are more likely to keep having one. And one thing we know, public health and health equity are more secure in a democracy than in an authoritarian state. So preserving democracy is critical to health.
Yeah, that's powerful words. I appreciate that. And it's almost like the flip side of the question is, if you don't litigate, what does that mean, right? If you assume that you'll lose, so why bother? It's kind of giving up before you even begin. And so I like this idea that, you fight that good fight, even if you have an uphill battle, especially if you get to that Supreme Court level, because we do live in a land with the rule of law and a democracy, and these things do matter, and we need to insist upon it and insist that they matter. The other thing I like about using litigation, and I mean, you're going to reference this when you talk about the lower court decisions, is that you get findings of fact, right? And those don't change at the Supreme Court. They might find technicalities to rule against a party, but they don't really change the facts. And so this is a place, the courts, where you get to tell your story and break through the noise that happens in social media and in the day-to-day, news cycle. And that story is kind of like giving testimony in a figurative sense that this is happening. These are real impacts. And that will hopefully be preserved beyond, the true social tweets and everything else that we're seeing.
Totally. I know we're out of time, but I just want to say, as you said, that it reminded me the decision I mentioned earlier about the NIH funding and Judge Young's decision. Litigation also leads to discovery and forces the government to disgorge documents and things that might otherwise be very hard to get. And so actually reading the judge's findings of facts and oh my God, they said this, and oh my God, they did that. I mean, it is also a way not only to tell your own story, but to tell a story about what the government did that would be much harder to find out if you were just like relying on FOIA or something. Litigation can help you gather information.
Yeah, for sure. So it's not the end all be all tool, but an important tool, because when you talk about trust in public health, trust requires truth, and litigation is one of those ways where we can hopefully get at some of that. So, well, thank you so much, Wendy, for walking us through all those cases. Really appreciate it. Hope folks found that useful. As we mentioned, if you do have questions about these or other cases, please do reach out to the Act for Public Health, to Wendy and her organization, or to PHLC. Please also join us for our next briefing. It's going to be on the executive silo orders, so the silo orders over data. My colleague, Madal Capagoda, is going to be leading a really great discussion on that. Hope you all can join us then. And when we close out this discussion, you're going to get a prompt for a survey. Please do take it seriously. We really do value your comments and your feedback, and we'll use those to improve these briefings. Otherwise, thank you again, everybody, for joining us today. Hope you found this useful and interesting, and appreciate your presence here.